Well, thank you very much, Sarah, and thank you very much, everyone, for joining this inaugural meeting of our new program. It is a great pleasure to be able to join you online, although not as great as a pleasure as it would have been to have joined you in person. And I hope that in this initial meeting, there probably might be a few technical glitches. Bear with us. But we continue to learn as we go along. I'm going to leave Rohan and Nihal, who have been far more engaged on the ground with the unfolding debate about the proposed constitutional amendment and how it affects the core principle of judicial independence, for them to speak more about the unfolding debate and the details. But let me sort of perhaps kick off this discussion with some of the background concepts and ideas that we need to bear in mind as we once again are faced with the prospect of a government holding the tremendous power of the executive presidency and a massive majority in parliament trying to tamper with the constitution. Not in the way that they were mandated to do by the electorate, but in other ways. So my topic for today is the independence of the judiciary as an inceptional value of constitutional modernity in Sri Lanka. My argument is that the independence of the judiciary is not merely one constitutional principle among many in Sri Lanka, but an inceptional value of Sri Lankan constitutional modernity itself. By inceptional value, I mean a foundational principle that appears at the key moments through which Sri Lanka has entered successive constitutional orders in the modern era, which for comparative constitutional purposes roughly begins at the end of the 18th century, and for our island in the early 19th century. These orders are the imperial, the dominion, the republican, and the contemporary order of constitutional democracy that we have. And I will approach this from two perspectives. Constitutional history first, tracing the institutional continuity of judicial independence from the colonial period to the present, and from the perspective of constitutional theory, showing how judicial independence became a central element of sovereignty, constitutional supremacy, the separation of powers, and the rule of law in our tradition of constitutional government. A central theme here will be continuity rather than rupture. Despite dramatic constitutional changes of regime changes in 1948, 1972, and 1978, the ideal of an independent judiciary links Sri Lanka's continuous constitutional development through the imperial and the post-colonial eras. And finally, I will suggest that this continuity is reinforced by Sri Lanka's long-standing identity as a Commonwealth constitutional democracy. Now, in the orthodox understanding of comparative constitutional law today, constitutional modernity rests upon several interconnected ideas: popular sovereignty, limited government, the separation of powers, fundamental rights, the rule of law, and of course, judicial independence. And among these, judicial independence performs a special function. While in a republican democracy, governments, parliaments, and citizens all have a role in the securing of constitutional government, an independent judiciary is the ultimate institution that transforms constitutional promises into legal realities. Without it, especially in a political culture that does not often self-enforce constitutional democracy as in Sri Lanka, rights become unenforceable and constitutional limits become purely political aspirations. This understanding clearly emerges in the preamble to the 1978 Constitution, where the people of Sri Lanka affirm representative democracy, freedom, equality, justice, fundamental human rights, and specifically the independence of the judiciary. And this is a remarkable constitutional choice because many constitutions refer generally to democracy or justice, and our constitution expressly singles out judicial independence as a foundational political value of the republic. And the implication is clear. A constitutional order worthy of being called democratic and sovereign and republican requires an independent judiciary. It is not a negotiable variable factor. Now, the roots of this principle long predate independence. Judicial independence emerged within the wider constitutional evolution of the British constitutional tradition. Classic constitutional cases, such as the case of prohibitions, Dr. Bonham's case, the case of proclamations, Bushel's case, all from the 1600s, and then Entick and Carrington in 1765, collectively established the proposition that law is not merely an instrument of royal or executive will, but an ordinance of reason for the common good, promulgated by those responsible for the peace, order, and good government of the polity. These developments became part of the common law constitutional inheritance transmitted throughout the British Empire in the late 18th, 19th, and early 20th centuries. In Sri Lanka, the critical moment was the Charter of Justice of 1801, very soon after the British had taken over from the Dutch the maritime provinces of the island, and which established the Supreme Court and introduced institutional safeguards associated with judicial independence. Of course, it was further institutionally developed in other key moments, such as the Charter of Justice of 1833 and so on. But this is the beginning. And this is significant because it shows that the judiciary was not a late Republican innovation that we adopted after we became independent. Indeed, the Supreme Court can plausibly be described as the oldest continuously functioning branch of the Sri Lankan state, 225 years now. While constitutions changed repeatedly, the courts endured. This institutional continuity is crucial to understanding Sri Lankan constitutional development and the role of the judiciary and of an independent judiciary in our constitutional imagination. The importance of judicial independence becomes even clearer when we consider the contrast between the 1972 and the 1978, the two Republican constitutions. The 1972 Constitution represented a decisive assertion, as we all know, of Republican sovereignty. However, critics argued that by its over-centralization of political power and legal authority in a majoritarian legislature in the pursuit of socialist developmentalism, it weakened key three features of constitutional democracy. First, the idea of constitutional supremacy. Second, effective protection of fundamental rights. And third, the institutional independence of the judiciary. Against this background, the 1978 Constitution, after the watershed elections of 1977, sought to restore both. This intention is visible in the preamble. The Constitution promises not merely democracy and justice in the abstract, but specifically constitutional supremacy at the end of the preamble, and then, of course, in the middle, fundamental human rights, and specifically independence of the judiciary. The preamble, therefore, reflects a recognition that constitutional requires institutional guarantees. The drafters appear to have understood that sovereignty alone is insufficient. Popular sovereignty has to be mediated through institutions capable of preserving constitutional government. And the judiciary is the principal institution that occupies that role. So in this respect, the 1978 Constitution, for all its faults, other faults, and there are many, can be understood as combining republican sovereignty, democratic government, rights protection, constitutional supremacy, and judicial independence into not only a single and singular constitutional vision for the Sri Lankan Republic, but what the preamble characterizes in rather magisterial terms as the intangible heritage that guarantees the dignity and well-being of succeeding generations of the people of Sri Lanka and of all the people of the world. So, an important place to begin an inquiry into the constitutional status of judicial independence in Sri Lanka, therefore, is not with the operative provisions of the Constitution, but with the preamble. I am currently co-editing a book for Cambridge University Press on constitutional preambles. Our contributors to this volume include some of the leading authorities in the world on preambles, including Liav Orgad, Justin Frosini, Nomi Claire Laza, and Adeno Adis. Now, they represent a rich diversity of methods, perspectives, and experiences, but they are united by one argument. Constitutional preambles should be understood as central rather than peripheral to constitutional law. Collectively, in our book, our core claim is that preambles articulate the justificatory grammar of constitutional orders. They explain why a constitution claims authority, in whose name it speaks, how it situates itself temporally, and what forms of political life it seeks to enable or constrain. In doing so, preambles occupy a very distinctive position at the intersection of law and politics, narrative, and ideology. Seen from this comparative perspective on a global scale, the 1978 Constitution is unusual in expressly identifying among its foundational commitments not only democracy, freedom, equality, justice, and fundamental human rights, but specifically the independence of the judiciary. This is significant because the preamble is not merely introductory rhetoric. It is the positive articulation of a specific application of timeless principles derived from what the preamble itself calls the intangible heritage of the people of Sri Lanka and all the people of the world. That legal act, that Aquinas called determinatio, the reasoned application of general principles to specific circumstances. The preamble is thus not a jumble of highfalutin words which have little determinate meaning in practice. It is an act of reason and specification and choice by the authorized lawgiver in the construction of an institutional polity from a factual or empirical one. In constitutional theory, this distinctive function of preambles is performed in two ways, expressing what Leo Orgad calls a constitutional's fundamental political decisions and its constitutional faith. The intellectual history of preambles can be traced back to, in the Western tradition, to Plato's laws. For Plato, a preamble was not simply an introduction. It was, and I quote, the soul of the law. Before the law commands, the preamble explains and persuades. The legislator seeks to secure obedience not merely through sanctions, but through reasoned acceptance of the moral purposes underlying the legal order. A law without such a justificatory preface was, in Plato's words, little more than a dictatorial prescription. Viewed in this way, the Sri Lankan preamble performs exactly such a function. Beginning with the ancient Sanskrit benediction of swasti, and thus registering continuity with all the traditions of public authority in both Sri Lanka and the wider Indic world, it invokes the well-being and legitimacy of a well-ordered commonweal that is the very basis of human flourishing, the condition which in the Western tradition Aristotle called eudaimonia. From this, the preamble moves into a universal and modern constitutional vocabulary: democracy, freedom, equality, justice, human rights, and judicial independence. The preamble, therefore, explains not merely what the Constitution establishes, but why it deserves authority and obedience. Judicial independence appears here as not just an institutional principle, but as a central part of the moral architecture of constitutional government under the Constitution. Now, the second intellectual lineage, when we are talking about this, comes from the common law tradition of which we are a part. Sir Edward Coke famously described the preamble as the key to open the understanding of a statute and the key to the makers. Similarly, Sir William Blackstone argued that where legal texts are uncertain, the preamble assists interpretation because it reveals the purposes and objectives that the Constitution or the statute seeks to achieve. This tradition is particularly important for Sri Lanka because it is a constitutional system deeply shaped by the common law and by the constitutional heritage of the Commonwealth. Indeed, in Orgad's famous typology of the world's constitutional preambles, Sri Lanka is firmly within the Commonwealth family of interpretive preambles, a tradition that is derived from Coke and Blackstone, in which the preamble functions as an authoritative guide to constitutional interpretation, even though it does not override the operative text when in direct conflict. This explains why Sri Lankan courts have repeatedly relied on the preamble when confronting major constitutional questions, including questions relating to sovereignty, fundamental rights, religion, the public trust doctrine, and judicial independence itself. The preamble therefore serves as a constitutional compass. It helps us identify the deeper principles that the constitutional text was designed to realize. From this perspective, the express reference to judicial independence in the preamble assumes a very special significance. In Commonwealth constitutional theory, moreover, a distinction is often made between the legal constitution and the political constitution. If the legal constitution provides the technical rules of government, the political constitution, of which preambles are often the most explicit statement, expresses a society's most fundamental political values and decisions. The commitments that define the constitutional order itself, its character, and its personality. The Sri Lankan preamble's explicit inclusion of judicial independence suggests that this principle was understood in 1978 not merely as an institutional arrangement, but as a foundational commitment of the Republic. And this reading is reinforced by the historical context. The framers believed that the previous constitutional order had inadequately protected both fundamental rights and judicial independence. The reintroduction of a justiciable Bill of Rights, the introduction of a justiciable Bill of Rights and the reintroduction of an institutionally protected judiciary therefore form part of the Constitution's broader project of constitutional renewal in 1977. And the preamble records that intention in the clearest possible terms. This interpretive understanding of the preamble also situates Sri Lanka squarely within the Commonwealth constitutional tradition, as I have mentioned before. Across the Commonwealth, courts have often treated preambles in the Blackstonian sense as interpretive resources that reveal the constitutional philosophy of the legal order. And the Sri Lankan approach mirrors this tradition. The Constitution's preambular commitment to judicial independence therefore cannot be dismissed as ornamental language. It forms part of what Orgad calls the nation's constitutional creed. When Sri Lankan lawyers and courts and citizens invoke judicial independence today, they are not merely relying on institutional arrangements contained in later chapters of the Constitution. They are invoking a principle located at the very threshold of the constitutional text and among the foundational values through which the people are deemed to have constituted the Republic. Thus, before we even arrive at Articles 3 and 4, the Constitution has already announced a crucial proposition. Judicial independence is not simply an organizational feature of government, it is one of the foundational principles through which the people of Sri Lanka understand representative democracy, constitutional government, and the rule of law to function. That foundational commitment becomes clearer when we turn to the constitutional architecture of sovereignty and the separation of powers, which is established in Articles 3 and 4. As you know, Article 3 declares that sovereignty is in the people and is inalienable, and Article 4 explains how sovereignty is exercised. Legislative power is exercised through parliament, the executive power through the president, and judicial power through courts. And although the phrase separation of powers never appears expressly in the Constitution, Article 4 implicitly embodies that principle. Now, what is also fascinating here is that Article 4 preserves a layer of Commonwealth constitutional history. It states that judicial power is exercised by Parliament through courts, except in matters of privilege and so on. This language echoes the old common law conception of Parliament as the High Court of Parliament. Yet at the same time, the Constitution does something distinctly modern. Judicial power is no longer rooted in parliamentary sovereignty. It is rooted in popular sovereignty and constitutional supremacy. The courts therefore derive authority from the sovereign people through the Constitution itself. The result is an important theoretical shift. The judiciary is not subordinate to government. It is one of the institutions through which the people exercise sovereignty. Judicial independence therefore protects not judges as individuals, but the sovereignty of the people. Sri Lanka's constitutional experience should also be understood within the framework of the Commonwealth. Sri Lanka was a founding member of the modern Commonwealth in 1949. The Commonwealth constitutional tradition consistently treats judicial independence as indispensable to democratic governance. This principle is reflected in many documents, including the Latimer House Principles of 2003, um, constitutional jurisprudence across the Commonwealth, and constitutional practice across member states. Key cases often cited when we teach public law in the UK and other Commonwealth countries, such as Macaulay and King in the 1920s, Hines and the Queen in the 1970s, all emphasize the importance of judicial impartiality and security of tenure. Now, from this perspective, Sri Lanka's commitment to judicial independence is not simply a domestic preference. It is part of a wider constitutional tradition shared across Commonwealth democracies, this family of nations. The Sri Lankan constitution, therefore, should not be seen as isolated or a nationalistic instrument in and itself, but as participating in a transnational constitutional community and an ongoing conversation about the rule of law and limited government. It's really very important, I believe, given the idea of the intangible heritage that the preamble says that we share with the people of the world, that this closest family of nations that share our legal values in the Commonwealth, that we see these values in the cosmopolitan rather than the sovereigntist and nationalistic terms that are often deployed in the idiom with which we speak about our constitutional values. Now, these principles remain obviously highly relevant today. The issue of public importance that we are gathered here to discuss, the NPP government's intention to introduce a constitutional amendment ostensibly to structurally reform the retirement age of all judges, but in reality, it seems to extend the tenure of the sitting Chief Justice, illustrate why judicial independence remains a living constitutional issue. And one of the central safeguards of judicial independence is the security of tenure. The purpose of tenure is not simply to prevent arbitrary dismissal. It is also to prevent governments from creating incentives, rewards, or expectations that might compromise judicial impartiality. Constitutional theory, therefore, regards judicial tenure as a matter of institutional integrity rather than personal advantage or the advantage of the government of the day to pursue mandates that they sincerely believe that they have received from the people for other objectives, such as dealing with rampant corruption and matters such as that. When constitutional mechanisms appear to be tailored towards particular individuals, concerns naturally arise regarding the separation of powers, what is going on between the president and the chief justice. Obviously, constitutionalism and public confidence in the institutions and trust. When people do not believe that institutions are working in the way that they're supposed to do, people begin to speculate about what is going on in terms of opaque conversations between individuals in high places, and low trust in institutions is a terrible thing for the health of our democracy. And these ill-advised initiatives like the NPP government's constitutional adventurism will contribute not to the strengthening and the system change that they were elected to put in place, but in fact to the opposite outcomes. Now, let me conclude with three propositions. First, judicial independence is an inceptional value of Sri Lankan constitutional modernity. It appears repeatedly at the foundational moments of each stage of the island's constitutional development. It's nothing new. It has been there from the beginning of our modern existence as a constitutional state, and that began under colonialism. Second, there is more continuity than rupture between imperial and post-colonial constitutional orders. The independent judiciary is one of the clearest institutional links connecting the Charter of Justice initially in 1801 through to the present time. And legal continuity is an extraordinarily important thing. It is one of it's one of the things that is good about Sri Lankan constitutional development, that we have never had revolutions and coups, even though 1972 was technically a legal revolution. So continuity is really very important, and it is something to be valued in and of itself. And the significance of the 1978 Constitution's preamble lies in recognizing this explicitly. Among the values that constitute the just and free society, it singles out the independence of the judiciary as a foundational constitutional commitment. And that promise remains as important today as it was at the inception of Sri Lanka's modern constitutional order. And it must be defended with clarity and resolution. Very often in Sri Lankan debates today, seeing it from outside as I do, a lot of people seem to believe that shortcuts must be taken with institutional constraints for the greater objective of dealing with corrupt people. This is a very dangerous thing. And I understand the temptation for the present government. In moments of democratic renewal, this was the first change of government after the Aragalaya through the ballot. Few causes are more popular than pursuing those regarded as crooks and thugs and beneficiaries of the corrupt old ancien regime. Yet there is a profound difference between holding individuals accountable and weakening the constitutional framework that makes accountability legitimate. To tamper with the Constitution and with that intangible inheritance of principles, conventions, and values that sustain it, above all the independence of the judiciary, is to flirt, perhaps unknowingly, with mortal danger to the Republic. Institutions painstakingly built over generations can be dismantled far more quickly than they can ever be restored. And when the passions of the moment have passed, it is not the powerful who suffer most from the loss of judicial independence. It is the people themselves, as we very well know from past experience. So the true test of constitutional statesmanship, therefore, is not whether we can punish our adversaries today, but whether we can preserve the safeguards that will protect our democracy in the future. So those are some of the thoughts that I think may provide a useful preface to the other presentations and the discussions to follow. I hope they were useful, and thank you very much for your time.